Hello, welcome to the video. I'm Dean Rod Vera, and today we'll talk about the controversial topic of who owns the phrase, eat bulaga. Stay tuned. Welcome back. Again, I am Dean Rod Vera. I am an intellectual property lawyer, and so we're going to talk about the copyright and or trademark of the phrase eat bulaga. As you know, over the last week of May and the first week of June, the show itself, Eat Bulaga, has been under a lot of turmoil. The Originally, Eat Bulaga as a noontime show has a block airtime with Channel 7 or GMA 7 for maybe 12 to 2 p.m. And the block time is owned by the company called Tape Incorporated. And so they are the producer of the noontime show Eat Bulaga. Its hosts are Tito, Vic, and Joey, and a lot of other personalities. And as of May 31, they all quit their association with Tape Incorporated, and according to news reports, they have moved. At least a show is going to be produced in Channel 5 or TV5. Now, question is, who owns Eat Bulaga? It's actually a complex issue wherein the ownership is either based on copyright or trademark. Now, the show itself is content. It is ruled by copyright. So in a sense, if a show is taped, no one can use the excerpts of that show without permission. But the phrase "Eat Bulaga" now is considered a trademark because it is a name of a product. The product itself is the television show. We have a rule in intellectual property law wherein if you're going to sue based on an intellectual property right, you have to sue either based on a copyright cause of action or a trademark cause of action. You cannot split. You cannot sue on both causes of action. Now, the phrase "Eat Bulaga" can be considered a copyright term if it's used as a artwork. If it's used as a title of a product or title of a show, then that can be considered what they call a song title. Now, there's been several jurisprudence in the United States that song titles by itself, is not subject to copyright protection. Here's what I mean. For example, you can use a song title that's copyrighted and use it as a phrase or part of another poem or a poem itself. For example, we all know Bruce Springsteen's "Born in the USA." If that is copyrighted, I cannot use that in an essay. I cannot say I was born in the USA because if that song title was protected, I can be sued for infringement by Bruce Springsteen. That is why song titles are not technically protected by copyright, but the song itself as a artwork, as an art form, is protected, even its lyrics as a whole. Now, the issue is, what is Eat Bulaga? According to Joey De Leon, he coined the term "Eat Bulaga," apparently talking to his young kid 40 years ago. Tito Soto, or former Senator Tito Soto, in a television news program, claimed that Eat Bulaga is protected by copyright because he claims it is protected from the moment of creation. That's on a copyright angle. Again, a title is not wholly protected as a copyright. So now we go to the trademark angle. Who owns Eat Bulaga as a trademark? Now, Eat Bulaga can be considered what they call an arbitrary or fanciful trademark because it has no connection to the show itself. It has no connection to the product it is associated with, which is a television show. There's a phrase, maybe it's a Tagalog phrase, a slang word. In fact, if my memory serves me right, the original artwork of Eat Bulaga was the letter E in Eat as a reverse Channel 9 because Eat Bulaga was in fact, I think, once in Channel 9 or RPN 9. Now, when you file for trademark, you can only get protection on the classes or classification of goods that you seek protection for, whether it be oil products, automotive products, paper products, and all sorts. There are several classes. Now, Tape Incorporated does own a registered trademark that was filed in 2011, approved in 2013, but only covers physical products or merchandising. It does not cover what they call Class 41, which is for entertainment. In February 2023, Joy De Leon, I think what's the name of the applicant, filed for Eat Bulaga as a trademark based on classification 41, entertainment classification. Then in March, the next month, Tony Vera with both Tito Soto and Joy De Leon also filed for a trademark using several classes, including Class 41. So what we have here is a registered trademark for Eat Bulaga. It has a particular artwork, but it's only protected as to the artwork itself. The applications from both Joy De Leon and Tony Vera and with Tito Soto is also just for the phrase Eat Bulaga, no logo. So what they're doing is protecting the phrase Eat Bulaga as a trademark for the classification under entertainment. Now, technically, Tape cannot go against the applications of both Joy De Leon and Vera because they are not in the same classification. Although the one with Vera has the same classifications as the one in Tape. But Joy De Leon's singular application is for Class 41. So now there's the dilemma. Who gets to own it? Now, again, as I said a while ago, if you sue based on copyright, you sue on copyright claims. If you sue based on trademark, you base it on trademark claims, which is used as a product, not as content. So, first, if TVJ, Tito Vic and Joey and the others, have a show on Channel 5 using the same format of a show, can they be stopped? No, because we have standing jurisprudence that the format of a TV show is not protected. Meaning if it's a game show or a hosting show or a news channel, the format itself cannot be protected. Hence, the Channel 5 version of the noontime show can replicate the contests, the gimmicks, but not necessarily the names, unless they're protected by copyright or trademark. The current show now in Channel 7, as of June 1, has several hosts but still uses the EB trademark as a background. Can Tito Vic and Joey stop them? No. Again, you cannot stop the format of a TV show. So it all boils down to the phrase Eat Bulaga. Who owns it? Now, the conflicting claims are that Joy De Leon he claims, the copyright of the phrase Eat Bulaga. Tape, the producer of the 43-year-old show, owns Eat Bulaga, but only a certain artwork, not the phrase Eat Bulaga by itself, for physical products, meaning for merchandising, and they don't own it for the classification of entertainment. We are now having a conundrum. In effect, both own it as to their own classification of goods. So, of course, you're going to ask me, can Tito Vic and Joey use Eat Bulaga as the name of their show on TV5? My simple answer is they can't be stopped. Because Tape's trademark ownership is not used for entertainment. If Joy De Leon says that he owns it as a phrase, Eat Bulaga, what art form is it? Is it a poem or a song title? There is a song, their theme song, It Bulaga, but that song is protected as a song, not as a TV show title. Did I confuse you? Well, that's what the lawyer's supposed to do. Confuse everybody, and then you can still get to pay us. All right. Let's cut it down to the brass tacks. Tape cannot stop the TV show on Channel 5 if it is called It Bulaga, because their trademark does not cover entertainment. If they use It Bulaga as a physical state in any backdrop or products, then technically they can be stopped from selling or showing the It Bulaga as a part of a physical medium, but only if they sell it. If it's a backdrop on their show, they're not selling a physical product. To sum it all up, both Tape and Tito Vic and Joey own their version of the phrase Eat Bulaga. They're technically not conflicting, and they cannot stop TVJ or Tito Vic and Joey of having a noontime show with the same style, format, contests or angles, because TV formats are not technically protected. So, what's going to happen? Apparently, according to news reports that I saw on TV, the law firm that Tito Vic and Joy hired will seek to cancel the trademark of Tape because it was filed fraudulently. Well, if it was filed in 2011, more than 10 years ago, it is very hard to assume or predict or know that Tito Vic and Joey did not know that there was a trademark application that was filed. We'll never know. I don't know what the defense will be. I don't know what the cause of action will say. Nevertheless, I already gave my opinion on this matter. Hey, just an opinion, not necessarily judgment. So, again, in my view, as an intellectual property lawyer, both knowledgeable in copyright and trademark, both own it, but in separate categories. Can they stop each other? I would say no, because, again, the trademark of Tape, the original producer of Eat Bulaga, only covers physical merchandise and not entertainment. So technically, they can't also oppose the trademark application of both Joy De Leon and Tony Vera and others. The developments will come forward in the next week or so, and if I have a chance, I might give an update video on this, depending on the outcome of any lawsuit that may arise. Again, this is Dean Rod Vera. Remember, it's not what you know, it's what they don't know.
Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.